Okay, welcome back. Have you take your seats? Good morning, once again. I'm Leslie Gielow Jacobs. I'm a professor here at Pacific McGeorge and also our director of our Capital Center, as the dean referred to. I'm so pleased to be able to welcome you here, along with Paul. Most of you know we have 3 centers here at Pacific McGeorge: our Global Business Center, our Advocacy Center, and the Capital Center. And each of the centers tries to do activities that include student education, deep community outreach, and scholarship. Well, this is the Capital Center's major scholarship event of the year, and we're so pleased to be able to host it. And I wanted to offer thanks to a number of people, because these things don't happen without it, and certainly Paul's the first one. Professor Paul Paton is the mover and the shaker behind this whole thing. He's runs our Ethics Across the Professions initiative, which is a 10-year initiative with events that go on each year. It's a lot of work, and thank you so much for doing it, and it's wonderful to be part of it. Thanks to the dean for hosting us here. And also thanks to our support. We at the Capital Center and all 3 centers have a couple of support people who make all this happen. That's Clemence Kuchera, who is my assistant, and also Ashley Patterson, who I think a number of you who are here have been dealing with. And so again, thank you to them for having it, and thank you also to the Law Review. It's really nice to be able to have a coordinated partnership going on between the faculty and the students. We've been trying to do that more and more. I hope the students are finding it fruitful. I know that we on the faculty side certainly do. And it's fun to be able to have students, practitioners, judges, academics all participating together on a day like this. With such an exciting and timely topic, as Professor Paton pointed out this morning. What are we talking about on this panel? Lots of questions in the handout, but basically we're talking about money and influence and judging and impartiality and how to put them all together. From a constitutional law perspective, which is the one that I bring to this, I find it interesting because I think what we're going to be talking about in this panel too is so circumscribed and influenced by judicial decision-making itself. That is, coming up in both of the papers, I know, and probably in the comments as well, are a couple of major Supreme Court decisions that have come out in the past couple of years. One of them being the Caperton decision. This is the one that involved the Due Process Clause, an interpretation of an individual rights guarantee, that said that essentially there is an individual right, at least in certain circumstances, to have a judge recuse himself because of the potential influence of, well, we'll debate that, of money on the election, on the decision-making process. And then, of course, the Citizens United decision that came out this year, which is an interpretation of the Free Speech Clause of the First Amendment, and sort of setting the other side of things, which is that there's a limit that the First Amendment imposes, according to the Supreme Court's interpretation, on the extent to which democratic institutions can act and make rules to prohibit the influence or the perceived influence of money on judging or the election of people, which of course includes judges as well. So in any event, it's going to be interesting to hear what these folks have to say about it. And in that respect, I do encourage you, as our presenters speak, to think about questions, because we are going to reserve a half an hour for questions, and so I'll be looking forward to seeing the ones that you have to offer. We have 4 people here today. 2 of them have produced papers. I think one of them is in your handout. One of them somehow didn't get in there, but they're both going to be in our law review. And then we have 2 people who will be commenting upon those. And let me briefly, I think I will do what Professor Paton did, which is I'll introduce each of you at this point so that we don't have to interrupt the presentations for the introductions. Who have we got? First of all, let's see, Professor Meryl Justin Chertoff. She's a visiting professor and also directs the Sandra Day O'Connor Project on the State of the Judiciary at Georgetown University Law Center. I should note we have people from all over the country here, we're very geographically distributed. Professor Chertoff let's see, the project that she directs studies and educates the public about threats to judicial independence. Before that, she served as director of New Jersey's Washington, D.C. office under 2 governors, and served in the Office of Legislative Affairs of the Federal Emergency Management Agency, participating in the agency's transition into the Department of Homeland Security from 2002 to 2003. From 2003 to 2005, she was a member of a legislative relations firm in Trenton, New Jersey, where she represented corporations, professional associations, and charitable organizations before the New Jersey State Legislature and regulatory agencies. She was legislative counsel for former New Jersey Assemblyman Richard H. Bagger and an adjunct instructor at Seton Hall University School of Law. She has served as a law clerk to a U.S. District Court judge and practiced for 7 years in New York and New Jersey. So we're certainly looking forward to what she will be starting off our presentation. We also have Professor Dmitry Bam, Dmitry Bam, who is a fellow at the Center of the Legal Profession at Stanford Law School. Let's see, Dmitry's scholarship focuses on the areas of judicial ethics, judicial elections, and the role of the courts in a democratic society. He's also active in the areas of court reform and access to justice, recently co-authoring a white paper on access to justice with Professor Deborah Rohde. Before joining the Center of the Legal Profession at Stanford, Dmitry was an associate at Morrison & Foerster and at Jones Day, and he was a law clerk for Judge Barry Silverman on the Ninth Circuit Court of Appeals. We have also Professor Ronald Rotunda. I think of him as a constitutional law professor, but I think people here think of him as an ethics professor too. He's joined Chapman University in 2008. Let's see, before that he graduated magna cum laude from Harvard and then from the Harvard Law School, and he was a member of the Harvard Law Review. He taught at the University of Illinois starting in 1974 after a circuit court clerkship, and let's see, he's co-authored and authored all sorts of things. One is Legal Ethics Casebook, Problems and Materials on Professional Responsibility, and he's also the author of Modern Constitutional Law, which is used in a lot of constitutional law courses. Let's see, he, more than 200 articles authored. He's been interviewed on radio and television and has served as advisor to a number of countries that are looking to reform their constitutions and on ABA, various committees, advisory committees. Finally, we have Professor Charles Geyh, Associate Dean of Research, and John F. Kimberling Professor of Law at the Indiana University Maurer School of Law in Bloomington. His teaching and scholarship focus on the operation of state and federal courts in relation to the political branches of government and the legal profession. He's also an author of When Courts and Congress Collide, The Struggle for Control of America's Judicial System, and co-author of Judicial Conduct and Ethics and Disqualification and Analysis under Federal Law, which is forthcoming. His work on judicial independence, accountability, administration, and ethics have appeared in over 40 books, articles, book chapters, and reports. He's received a number of teaching awards and served as a law clerk on the 11th Circuit, worked at a major law firm, Covington and Burling, served as counsel to the U.S. House of Representatives Committee on the Judiciary, and taught at Widner, and before he joined the faculty at Indiana. We're certainly pleased to have all of you, and I'll introduce Professor Chertoff.
Thank you so much, Professor Jacobs, for that kind introduction. Ladies and gentlemen, I'm delighted to be here, and I wanted to thank Dean Parker and Professor Paton for putting on this wonderful program, very exciting set of issues being discussed. Sorry, a little better? Okay. Professor Jacobs' very kind introduction referred to my having represented people in front of the New Jersey legislature. It's a very nice way of saying I was a lobbyist. So I'm perhaps a little less academic than some folks, and before I talk to you about some of the very practical things that are going on, I do want to set it a little bit into the context of the last panel, which was talking about the elimination or the efforts to eliminate bias in the judicial decision-making process. And that is an admirable goal, and certainly there are some wonderful ideas that came out of the last panel to do this. I'm a bit more of a skeptic, and so I want to focus on the institutional ways that we can try to take some of the bias out, and those refer to structural and systemic ways of taking bias out of the system, and I'm referring specifically to biases that can arise out of the judicial election process. So I come to you with the confession of a reluctant fan of merit selection in state judicial selection. For the past 3 years, I've worked with the Honorable Sandra Day O'Connor, retired Associate Justice of the United States Supreme Court, at the Sandra Day O'Connor Project in Washington, D.C. And Justice O'Connor, as some of you may know, since her retirement has become an outspoken advocate of the merit selection method of picking judges in the state courts. I want you to know that when I began this work, I was a skeptic, but I've seen the light, and it's not just because of the considerable force of personality of the great American that I've had the pleasure to work for. I came into the project coming from the state of New Jersey, which has one of the few pure judicial appointment systems of the states. The New Jersey system is one in which sometimes we call it the imperial governor system. Judges at every level, from the state Supreme Court down to the lowliest trial level, are selected by the governor. So it's really a system that's sort of at one extreme of judicial selection in the country. And it's a system where the governor has an enormous amount of power. The framers of our New Jersey Constitution, when they convened, they were very skeptical of popular selection of judges. They were very skeptical of the legislature, and they wanted to put the selection process in the hands of the most elite portion of the state. And so they determined that this would be the best way to do it. Now, as it happens, I think the system in New Jersey has worked very well. It's quite similar to the federal system. It's accompanied with some fairly rigorous judicial canons of ethics, and I would not trade it. However, I have also seen the way that the selection process works in New Jersey and elsewhere. And I know, as in making legislation, sometimes you don't want to look too closely at the process. There are compromises that go into it. We're not always pleased with the outcomes. But I had always been quite a fan of the process that was used in New Jersey. Having said that, I am also a fan of elections as a general matter, because I do think that people can be fairly wise about making their own decisions. And so, as I say, I came into the process as a skeptic. I liked the way it was done in New Jersey, but I saw elections as being another potential way of picking judges. After all, why are people less wise than panels of experts? And I'm going to argue to you now that the problem is that there is a question of institutional legitimacy that arises when judges are elected. That, in fact, judicial elections that involve money are different in nature and in kind than any other way of picking judges. So first, let's look at the two interests that are at stake. First, judicial independence, and then accountability. My good colleague, Professor Geyh, has talked about judicial independence in one of his many articles, talking about judicial independence not only as a good in itself, but more important as a good because of what it permits judges to do. That is, it's thought that if judges are independent, they will enact the rule of law, they will have more adherence just to law, fidelity to the rule of law, than if they are picked without having that independence. The other side of it is accountability, and those who like accountability, for example, Harold C., who is a professor of law and a former justice of the Alabama Supreme Court, they say that the problem with judges who are not elected is that those judges may work more like legislators, and if they're going to act like legislators, then judges should in fact be elected. Well, why do we care if judges are independent? And we care because the institutional role of the judge to protect individuals from the tyranny of the majority. So when we come into the courtroom, and many of us may at some point have to go into a courtroom, we come in as a minority. We come in as a party of one, and we want to feel that our rights as individuals are protected. That is the value of having judicial independence. We feel that the judge who is deciding our case is independent, adheres only to the law. That gives us an institutional confidence. Now, does independence mean that a judge does just what he wants? Of course not, because first of all, judges are bound by the law, they're bound by precedent, they're bound by the codes of ethics, they're bound by a strong legal culture. And most of this, almost all of this, no matter how they are picked, judges try very hard to do their job well. So judges try to adhere to the rule of law. They try to be ethical. As we heard in the last panel, we all come to this with bias, but judges, their institutional and cultural role is to try to rule without bias. They're a very serious lot. I know a lot of judges. And even when their decisions are criticized for being capricious, the judges who make those decisions are not capricious in the least bit. In the US, at least, judges are very serious about the rule of law. And because they have historically been so serious about the rule of law, we have been able successfully to export American notions about the rule of law abroad. We don't, in the States, always carry that out as well as we do in exporting those notions of rule of law abroad. There are so many checks on judges internally within the system in terms of checks that already exist on judicial independence. For example, in the literature on judicial independence, there isn't usually a great deal of discussion of juries. The jury system exists in order to provide a balance to the rules of judges at the trial levels. Juries were put into the system to balance the common sense of the people against the dictates of law, and even as a check against the bias of judges. Another check in the system is appellate review. There are generally two levels of appellate review. And there's a third check, which is the system of judicial ethics proceedings. So even in the most extreme version of judicially independent selection, there are many institutional checks on the independence of any individual judge. And that, of course, also, the number of checks grows at the lower down you are. So at the trial level, there are the most checks because there's a jury, then there's the appellate level of court, then there are the ethics panels, then there's the Supreme Court. So that's 4 levels of independence, of checks. And so I would submit to you that the place where we need elections the least would be at that level, at the trial level. So let's take that out. You don't need to have elections at the trial level. There are lots of things to check that judicial independence for trial level judges. Okay. So how about the intermediate appellate level? Well, there's a level above that, and then you can potentially go to the U.S. Supreme Court. So let's say we can say, all right, at the appellate level, you also don't need to have judicial elections. The accountability factor is already there because of institutional checks. So then that takes us to the Supreme Court level. The Supreme Court level in the states is where a lot of the action at the practical level has been in terms of judicial elections. That's where multi-million-dollar campaigns have gone on. That's where there have been these sort of appalling ad campaigns which have tried to tar particular judges for maybe one decision that they have made out of 100 decisions that they've made. So that's where the problem is. And why are the stakes so high in state Supreme Court judicial elections? Well, we saw it in the Caperton case. We saw it in the Caperton case because in that case, Don Blankenship gave $2.5 billion of his own money and another $500,000 of other money in order to support the campaign of who became Justice Benjamin of the state Supreme Court. And then Justice Benjamin was the deciding vote on a case involving Massey Coal. And the name Massey Coal may ring some bells now because Massey Coal has just been involved in this awful mining disaster. And so one might argue that the $3 million that Blankenship spent might have better been spent on mine safety rather than on trying to influence judicial elections. And that's not irrelevant, I'll come back to that, because the economics of the situation are such that there is a real question as to whether it's economically efficient to elect our judges. But the question in the Caperton case came down to whether there was a due process violation because Justice Benjamin did not recuse himself in deciding this case of the single largest contributor to his campaign. And what's interesting about the way that the facts were presented to the Supreme Court is this was a 5-4 decision. And the question that I would ask is, let's say that Blankenship had been engaged in a longer-term strategy. Let's say that that wasn't the deciding vote. Let's say that it had come out the other way, 4-5. Now, would there have been a due process violation? Arguably, the wrong was the same, because the wrong was that the vote, at least the allegation was, the vote was actually influenced. But what if there had been a different decision? Would that have been there wasn't a due process violation? Of course, the due process issue would have been the same. The petitioner wouldn't have had the standing, but the issue of due process would still have existed. And so the question becomes this: is what the right was, the due process right, a surrogate for an institutional interest, an interest about the legitimacy of court decisions? And I would argue to you that whether you talk about this in terms of appearance or whether you talk about it in terms of probability of actual bias, we're talking about something which is really about the way the people view the courts, whether we have confidence in the courts. And there was a lot of discussion in the opinion as to actual bias, appearance of bias, but I would say that the very technical term, there was something about the way that case was decided in the West Virginia Supreme Court that was not kosher. That's the technical legal term for it. So when you look at the cases that were used as precedent for that case, they're cases about money. One was a case in New York where the judge made decisions, and if the defendant lost, then he paid a fine, and $12 out of every $100. Wow, really? $12 out of every $100 went to the judge. A very small amount of money, but it was money in the system that was problematic. So there are all kinds of soft bias that judges have. There are biases because their kids may be on the same softball team with the kid of a litigant. They may have attended one another's wedding, which is actually a hypothetical that the Chief Justice posed to Ted Olson when he was arguing the Caperton case in the Supreme Court. What about those biases? There are all kinds of biases that we come to. But in the American system, we look at money differently. Money is considered to be something which is an inappropriate thing to use with respect to judicial decision making, whereas we are willing to have campaign contributions to legislative candidates. There's something that strikes us funny about having campaign contributions for people running for judge. And that is why I would say to you that a paradigm shift where we take the money out of the system makes an awful lot of sense. Now, I've gotten the 3 minutes here, so let me go on a little bit. My colleague Dmitry here has observed that participant polling says that judicial elections are popular, and it's true that when you poll and you ask people, do you like, if in an elected judge says, do you like being able to elect your judge? And they go, oh yeah, we like being able to elect judges. And in the work that we've done over the last 3 years, when we've gone to legislators and we've said, we'd really like you to take a run out of replacing the system that you've got, which is the elected judge system with a merit selection system, they said, well, I don't know, we can't do that because, people are going to say, you're taking away my vote. oh my gosh, you're taking away my vote. I don't like that idea. You're taking away my vote. That's a terrible thing to do, take away my vote. But in fact, sometimes legislators take the lead on things that are not popular. If you look at the healthcare debate that has gone on, and if you looked at the polling in that, healthcare reform was not popular, and yet the Congress took the lead and passed the bill. And why did they do that? Their explanation is, oh, there are my glasses here all along. They took the lead on that because they believed that they would educate the American population to understand why the new system was better than the system that it had replaced. And what I'm going to argue to you is this. People would accept a non-elected system of judges, a merit selection, so-called merit selection system, better if they understood just what it was they were getting and what it was they're giving up. That's what the Sandra Day O'Connor Project has been doing. Justice O'Connor has gone out all across the country. She's spoken about this. There are other advocacy organizations that are working on this question right now, and they're getting better at it. And one of the things that will happen as a result of both the Caperton case and Citizens United is that there's going to be a lot of discussion now about the role of money in the way that judges are picked in the state. There will be an increased focus on it. We view this, the people who are interested in doing merit selection, as a real opportunity. We view this as an opportunity to educate the public and to cause people to think about whether they really want to see all this money going to elections, to continue to see these kinds of ad campaigns. And we think that the answer is with an elected public, with an educated public, you will see less passion for electing judges, and you'll see a more nuanced understanding of why you can do the job just as well. And just very briefly, before I wrap it up, I think that a number of you are familiar with the merit selection system, but for those who are not, the merit selection system does not take away accountability. Merit selection is a system where initially a panel of candidates are submitted to the governor. Governor makes the initial pick. The judge serves for a period, a shorter period of time, 2, 3, 4 years, then is submitted to the people for retention election, up or down. It's not partisan. There aren't multiple candidates on the ballot. It's an up or down election. So there is an element of accountability in it. In some of the states where it originated, like Missouri, it was criticized because there was some sense that these were being dominated by the plaintiff's bar, by personal injury attorneys. But there have been refinements to the system in a number of states, including Arizona, which is Justice O'Connor's home state. And in Arizona, the process is very open and transparent, with public hearings and with minority of the people on the commission being lawyers. And that's key, because one of the chief criticisms of merit selection is, oh, it's dominated by a bunch of lawyers. It doesn't really reflect us. But in fact, in Arizona, it does reflect the composition and the diversity of Arizona. It's a very open process. And I like to compare the merit selection system in Arizona to a jury. It's regular folks, but regular folks who are much more educated than most of us want to bother to become about any given judicial candidate. So there briefly is why I have become a convert to the idea of merit selection. And I thank you for your time and attention.
Well, I too want to thank Paul for organizing this event, and it's an honor to be here on the panel with some of the top scholars in the field. I do want to say a few words about the Supreme Court's decision in Caperton last year and what I think it means and how I think we move forward from that decision. Before I do that, I think it's important to understand how recusal fits into the general scheme of this accountability independence framework that the last panel talked about, and that you're going to hear about in this panel as well. I think it's important to see recusal not as a standalone issue, but as part of the judicial selection framework, the judicial independence and judicial selection framework. So as lawyers, we like to have clear tests and bright lines and put things in boxes. And so as people who write on the judiciary, the independence and accountability are the two boxes that we really like to think about. And so these aren't well-defined boxes, and most things you hear about today don't fit neatly into one box or the other, but they're good heuristics, they're good shortcuts. So when you're listening to me or when you're listening to others make their presentations, ask yourself how you think what you're hearing, how the proposal fits into the independence accountability construct. What implications does a certain proposal have for judicial independence or judicial accountability? Let me explain those two boxes just a little bit more. When we talk about judicial selection, there's a tension between what Alexander Bickel talked about in terms of counter-majoritarian dilemma and what Stephen Crowley in a recent article called the majoritarian dilemma. So the first, the counter-majoritarian dilemma, is a concern about the legitimacy of unelected, unaccountable judges setting rules or policies. And I think very few people these days would dispute the notion that judges do set rules and policies that govern the people in that state. So in the federal system, federal judges are generally not held accountable for their decisions, can decide cases based on their personal policy or political preferences. And empirical research says that a lot of that is going on. The second one, the majoritarian dilemma, is the opposite concern. It's a concern that it's a concern with the elected judiciary. We worry that elected judges will make rulings based on what the majority wants. They'll tailor their decisions based on whatever they think will get them reelected. And as I'll discuss in a couple of minutes, this concern is also justified. The empirical data bears out that this does in fact happen. Now you heard talk about independence, but independence is a term that's hard to define, and nobody disputes that independence is important. People who support judicial elections also agree that independence is an important part of the judiciary. So we should always hear when somebody we should always ask when somebody talks about independence, is independence from whom? Because independence from a legislature is something very different than independence from the majority of the people, and something that's very different from independence from special interests. And so when we're seeking independence from the legislature, we may want something very different from a judicial selection mechanism than if you want independence from the majority of the people. So election critics, and Professor Chertoff is one of them, argues that judicial elections forsake judicial independence in large part. But keep in mind that the judicial elections came about to increase judicial independence. Elected judges, of course, are less independent from the people, but they're more independent from the legislature or the political parties. In a recent article, Judge Sugarman confirms that once elections became popular in the 1840s, elected judiciaries were much more likely to strike down legislative acts than appointed ones. And the purpose of judicial elections was to make sure that the judiciary was separate from the legislature, that special interests don't play too much of a role in our judiciary. So in deciding how to select judges, we have to balance those two interests. There's a wide spectrum of selection systems, as Professor Chertoff talked about, that have struck the balance in different ways, from appointments by executive, like in New Jersey, or the federal system, to a merit system, where a committee makes a recommendation to an executive who makes the appointment, to all the way to full elections, and even there you have a range of partisan elections, nonpartisan elections. With each one, there's a compromise. In a system like the federal one, we have a relatively high level of independence, but I would argue there's little accountability, contrary to what Professor Chertoff said today. Judges can and often do decide cases based on their personal preferences. In a fully elective system, we hold judges accountable, but we worry about their independence. Will judges interpret law not according to what it says, but what will get them elected? Some of the recent empirical data shows that criminal sentences get harsher as judges approach re-election. Some of the research shows that judicial decisions line up more closely with the perceived political preferences of the constituents, the so-called constituents that are going to be voting for the judge, and that's a concern. In the United States, most states have opted in favor of an accountability model, meaning that most state judges in the United States face some form of an election. And a lot of academics, scholars, and judges think this is a bad idea. The movement by Justice O'Connor to eliminate elections is a strong one. And we hear about this tension that while most people favor judicial elections, a similar number of people, a similar percentage, is concerned about judicial independence and impartiality of judges. What I want to suggest is that this tension is illusory to some extent and should be resolved in favor of elections to the extent the tension does exist. So what do I mean when I say it's illusory? When people talk about judicial elections or express their support for elected judges, they're really talking about a very small percentage of cases, and nearly all of them constitutional law cases. People want to elect the judges who interpret broad, vague clauses in constitutions. Clauses like the due process of law, equal protection of the law, freedom of speech. People want to have a say over how judges approach those cases and what decisions they reach. And rightly so. After all, the Constitution is the will of the people. But most cases that judges decide don't involve a constitutional question. Think about a slip and fall tort case or an employer-employee dispute, a car accident. I believe in those cases people don't particularly care about judicial elections. I personally don't think 80% of the people would really care about whether or not a judge presiding a dispute between two corporations about whether a certain provision of a contract was breached was elected. But those are the very types of cases where the probability of bias is the greatest. The insurance company, a large corporation like Massey in the Caperton case, are the ones who are most likely to have contributed to the judge. In other words, when people say that they overwhelmingly support judicial elections and then overwhelmingly say that they are concerned about partiality that judicial elections may create, they're often talking about very different types of cases. So the problem, as I see it, is that in literature and in these discussions, we often treat judges as a monolithic, as a homogeneous category, whereas in reality, a judge interpreting the Due Process Clause is doing something wildly different than a judge interpreting the Uniform Commercial Code. I also think there's lots of reasons to err on the side of accountability when choosing between these two models. And I'm happy to answer questions about what those are, but I don't want to talk about one in particular. I think it's much easier to play in the margins with an accountability-based model than an independence-based one. Once we opt for an independence-based model like the federal system, I think it's very hard to bring accountability to the system. So you can have President Obama sort of browbeating the judges in a State of the Union address, but that only goes so far. Professor Chertoff mentioned juries, but in those cases where I think accountability matters the most to the people, juries don't play a role in interpreting the meaning of a broad clause like the Due Process Clause. Same thing with appellate levels. You know, if we live in a state where judges are appointed, the appellate judges are appointed as well. So it doesn't bring much accountability into the system. Now, that may lead to good decisions, like Brown versus Board of Education. It might also lead to bad decisions, like Dred Scott. Studies show that people have a hard time separating their personal policy preferences and their political preferences from their legal decisions. You know, I clerked, as Leslie mentioned, for a judge in the Ninth Circuit, and I think it's problematic that based on the composition of a panel, you could predict the outcome of a case without knowing any of the legal issues involved. You could hear what the question presented was, and if Judge Pragerson was on the case, or if another liberal judge was on the case, you knew the outcome would be for the criminal defendant, and if a conservative judge like Judge Scanlon was on the case, you knew the outcome was more likely to be in favor of the government. And I think that's a problem. You know, today we have people going to blogs and playing fantasy Supreme Court games where they can predict with reasonable certainty what a vote is going to be in a certain case per judge. I think in an accountability model, we can tinker with it at least to increase judicial independence to some degree. One way to do that is to do what Professor Jay talked about as increase institutional independence. Give judges longer terms, make impeachment more difficult, not allow lowering of their salaries. Another way to do it is via election reform. Justice O'Connor is a really strong voice to eliminate elections, but there isn't a strong voice out there to change elections as much. Now, part of it is the overreaction to the White and Citizens United cases, where people are worried about how difficult it is to change elections after the Supreme Court rulings in those cases. But public financing, restrictions on speech other than the announce clause that was in the Republican Party of Minnesota case, greater disclosure of where the money is coming from after the Citizens United case, those all can increase judicial independence in an accountability-based model. And of course, that's where recusal comes in. That's where I see Caperton plays an important role. The main problem with elections is that the very people who work to elect the judge are the ones who appear in front of the judge as a party. And I was shocked, and you'd probably be shocked, how often that actually happens. In a recent study in Pennsylvania, suggests that over half the time, almost 2/3 of the time, at least one of the parties or their lawyers contributed to one of the Supreme Court justices in a Supreme Court case. The problem is we need to make recusal more aggressive to eliminate this situation. And we need to tailor recusal procedures to the evil that we're trying to resolve. Now, in the past, the way we did that is by changing substantive recusal rules. And so now we've ended up with this appearance of bias standard that was talked about in the first panel. In other words, if it appears to a reasonable person that a judge is biased, recusal is necessary. It's a strict standard, and it's a great standard, until you realize that nobody really applies it and it doesn't work. What I mean when I say that nobody applies it, it's really just a fig leaf. It allows judges to take themselves off a case without ever admitting presence of bias. When I began doing my research, I talked to a few judges about what they thought about the appearance standard, and most liked it because it gave them the opportunity to say, hey, I'm not biased here. I don't have to admit that presence of any actual bias, but some average person might think that I am. I'm not even sure judges are actually applying this test. I mean, I think some of the literature suggests that judges are actually still asking whether or not actual bias exists, but then couch it in the terms of appearance of bias when they have to make the recusal decision. What I mean when I say it doesn't work is that it's sort of a silly standard in practice. You know, Professor Chertoff mentioned that it's not kosher. There's something not kosher about the Caperton case. But you know, to put a finger on what's not kosher about it, I think first and foremost is that we're asking the very judge who's arguably biased to make the decision whether or not he's biased. I think that's problematic. So in a situation like Caperton, where we have an accusation that the judge owes a debt of gratitude to one of the litigants, presumably the same debt of gratitude would exist in the recusal decision as would exist in a substantive decision. Furthermore, research shows that even very minor contributions may lead to an appearance of bias, whereas we may not want judges in those cases to recuse themselves. For example, Jim Gibson, who's a political scientist at Washington University, conducted a study where he asked people questions about the facts on Caperton, but altering them slightly. He found that most people in a study were concerned about impartiality even when the contribution to the judge was fairly minor, described as insignificant to have made a difference in the election. In fact, he found that most people were worried about partiality when the contribution was offered to the judge and rejected by the judge. As I read Caperton, I think the court abandoned the appearance-based test under the Due Process Clause, focusing instead on a probability of actual bias test. As I see it, those tests are different. I view probability of bias-based tests as more focusing on the likelihood of actual bias and not looking at the appearances that it creates. I think getting away from appearances in the substantive standard is a good thing. But that doesn't mean that we shouldn't consider appearances at all. I think we should change how the appearances are considered. Appearances should matter to the legislatures that are creating the recusal rules in advance. In other words, state legislatures should tailor recusal more closely to the problem that exists. In the long run, however, I don't think the Caperton decision alone will make a big difference. I think judges were already required to recuse themselves even when there's an appearance of bias. So having a constitutional standard that in my view is a lesser standard, probability of bias standard, won't change anything in and of itself. Caperton can only make a difference if it leads to large-scale procedural changes. Changes like election reform, like having other judges or independent panels decide recusal motions, requiring judges to write opinions, explaining their recusal decisions, and by a less deferential review of recusal decisions by appellate courts. Now, if these things happen, I remain fairly positive. I know some people are fairly negative on judicial elections. I think these changes can happen. And judicial elections may not be so bad after all if they do happen. Thank you.
We're going to be switching the order a little bit, and we'll hear from Professor Geyh first.
The reason I'm going is I've got to catch a plane back, and the organizers were kind enough to let me speak next, which actually is only so kind because I came here prepared to comment directly on the papers themselves, and both speakers have departed from their script considerably, so that if I went ahead right now and commented on the papers, I could just as easily show you pictures of my family, and it would be equally relevant. So I am going to be shooting from the hip here. We will see how it goes. I think we've talked a lot of, and I want to contextualize this. We've talked a lot about independence and accountability. And to me, I think the way we need to think about it is to say that they aren't. I mean, I don't like Dmitry's sort of dividing them up and saying you have independence oriented regimes and accountability-oriented regimes, and that the federal fits into one category box and the elective system fits into the other. To me, independence ends where accountability begins, and really what all of us are trying to struggle for is where we draw the line, so that you can draw the line and say, Meryl is saying, for me, it's tipped the issue between elected and appointed judiciaries. We tip the balance at that moment where money starts getting inserted into it. All the other arguments, sort of you can go either way, but once we start worrying about the corrosive impact of money, the benefits of accountability by having people accountable to the public are offset by the corrosive impact of elections. Right? And I think Dmitry is arguing, on the other hand, that the federal judiciary is largely unaccountable, and that the public has a right to judges who are going to be responsive to public concerns on issues that matter most to them. Right? On issues where the law is the most disconnected or obscure. Now, I guess to me, I began this process about 8 years ago as a rabid opponent of judicial elections, and wrote an article entitled "Why Judicial Elections Stink," in case there was any room for doubt as to my point of view. I have since become a born-again agnostic, but not for the reasons that Dmitry talks about. To me, I think it is false to say that the federal judges are utterly unaccountable. I mean, to begin with, they are appointed by presidents who, on the whole, are trying to appoint people whose political philosophy aligns itself with the elected majority. And yeah, they drift over time, but on the whole, they are comporting their views to the views of the majority. And indeed, in an elaborate book and wonderful book that Barry Friedman has recently published, I mean, we see that there really isn't a counter-majoritarian problem all that much at all. It's not as though the decisions of the federal judges are all that far apart from the will of the majority most of the time. It's just simply, it's just not as big a problem or a difficulty as we might suppose. So, I mean, that's part of it. The other is that, I mean, in Dmitry's comments on elections, he talks about generically about federal judges following their policy preferences. You need to differentiate between courts. The data on the Supreme Court, the final word, really does show that you can predict 70% of the time where they're going for reasons other than the facts and law of the case. But they're the final word, and it's understandable that they're perceived as policymakers. Frank Cross and Stephanie Chin and others have shown pretty persuasively that at the lower court level, the political culture and the rule of law culture really does regulate judges in ways it doesn't at the Supreme Court. And all of the elements that Meryl talks about as contributing to judicial accountability are in play. So none of this winds up leading me to say, therefore, elections are stupid and we got to appoint judges. I mean, all it means is that it's not as close a question as saying, well, one system is all independence and no accountability, the other is all accountability and no independence. It is far closer than that. To me, my biggest concern, in some ways, this doesn't let Meryl off the hook entirely, because I think there is an extent to which you have the friendly fire problem. I'm sympathetic to the point she makes, but she comes back to what she regards as the ultimate problem, which is, okay, we can talk about this as a lovely academic argument. To what extent is any state going to up and change its system and get rid of its elections? Right? And that's not a reason not to favor it, but it is a reason to worry about it if you care how this is all going to play out in the end. And I mean, I think, my views are informed by a couple of developments. One is, whenever we get together and talk about this, we have a tendency to think about judicial elections in a vacuum. We're either for them or against them, and we divorce it from context. When in reality, each of the 50 states have their own political cultures, their own constitutional histories, where in some cases the populist culture of the locale means we don't trust our judges enough to go off and make decisions without our help. And in those jurisdictions, going after a merit selection system is probably a waste of time for the moment. And we can talk about informing the public, but if they have a deeply entrenched history in favor of electing judges, you've got not just an uphill battle, but perhaps a waste of time. So one size doesn't fit all is part of my message there. The other piece is that the political viability of merit selection changes over time. that it seems to me that one of the ironies right now is that we're in the midst of a full-blown attack on a lot of state judges for a lot of reasons. They're going after them because of their decisions. There's money pouring into these races. And at that point, it's understandable that we stand up and say, let's move to a different system. The irony there is that it's precisely the wrong time. That's the time when the public trusts judges least. That's why there's all this attention being paid to it. And that's why I think that it's least likely to be a terribly effective mechanism to go after judges at a time when what really gives them their legitimacy is their electoral accountability. If you'll note when merit selection has had their most effectiveness, it's been in the aftermath of cycles of anti-court sentiment. You know, when things have calmed down and when you can sell the argument, look at, wouldn't you rather have a judiciary in which we take advantage of the expertise and qualifications of the judges and where we don't worry about pressuring them into making popular decisions, where we don't have all of this money trouble. So in some ways, I guess my point is that when we talk about the merit selection movement, we need to be more opportunistic about it and I think be a little bit more selective in the way we look at it. Now, whereas Meryl is talking about looking at a way to deal with the problem of money in elections by way of ending elections, Dmitry's paper, at least, bears down on using the disqualification scenario as a way to do that. And in so doing, I think he, you know, as you saw a little bit of this, he's pretty skeptical of of an appearances-based standard in the disqualification regime and sees it as nothing more than a fig leaf that enables judges to walk away and disqualify themselves for anything. And I think that's a little unfair to the appearance-based standard. First of all, I think it's important to understand that appearance does not appear as a word in the standard at all. I mean, that it really is a standard that says, might your impartiality, you know, you have to ask yourself if the judge's impartiality might reasonably be questioned. Now, you can infer appearance from that. I mean, what you can basically say is, well, what you're really asking is whether it would appear to a reasonable person that the judge has been biased. Now, he goes on then in his paper to say that that really opens the door to, you know, the reality that in polling data we show time and time again that people think that judges are influenced by their campaign contributions. And if we follow an appearances standard alone, we'll be disqualifying judges for all of that. And I don't think that's fair. Because we aren't really, the standard doesn't say, look at polling data. The standard says whether a reasonable person, fully informed of all the circumstances, would look at this judge and say, you might not be impartial. And the norm here is that in a fully informed person, knowing that a few $100 by a large law firm in a major campaign isn't going to influence anything. And that helps to explain why the vast majority of times judges don't disqualify themselves for contributions of that kind. Strikes me it's rightly decided. The appearance standard does just fine. Moving toward this probability of bias standard is one that strikes me as a little bit problematic, in large part because, you know, it strikes me as a dopey standard. You know, I think that as a you know, if you step back and ask yourself, is Caperton an easy case? I think it is. But, you know, if you step back and the way to look at it is, suppose you're a normal person, by which I mean someone who's never seen the inside of a law school, okay? And you take them aside and say, look, the Constitution says that you have a right to due process of law, which means fair process of law. Now let me tell you a story. And the story is, there's a fight between two companies. One's accused of doing nasty stuff to the other. The one that's the victim sues the other, wins a $50 million verdict in front of a jury. The loser then decides to appeal to the Supreme Court, but he sees someone on that court that's not to his liking, and so he spends $3 million to get him replaced with someone better. Bam, the new judge refuses to step aside and casts the deciding vote in a 3-2 vote. Does that strike you as a fair process? No, because it doesn't meet the standard. It's only when lawyers get involved that we start ending up saying, hold on, it's complicated. Because if we use this probability of bias standard, yeah, it's difficult. Because how the hell are we supposed to tell if someone's probably biased? Right? It's because it's not like blackjack. It's not like counting cards where you can say, oh, there's a 47% chance of getting a face card. It's not like that at all. The most you can do, what does it mean? What it means is that if you're asked about this, you say, well, we're reasonable judges, and it appears to us, an appearance standard, that this judge is probably biased based on these facts. So that at the end of the day, it seems to me that what the court has done in Caperton is created a two-tier structure. We do have the state rule which says you got to disqualify yourself if your impartiality might reasonably be questioned. And for due process purposes, you've got to disqualify yourself if your impartiality would reasonably be questioned. That's kind of where we are. I'm okay with that. I don't like the idea of morphing toward a probability standard in state rules. I like the idea that you can create a more stringent standard at the state level and say, okay, let's create a hard and fast rule. Let's create a conflicts rule that says if you got X amount of dollars in Y-sized campaign during the pendency of the litigation, you step aside. All right? Because then we'll presume that you've created an appearance of partiality, and you got to step aside. I'm okay with that. And I'm likewise okay with the probability of standard being reserved for due process cases, which I think is another way of putting it, it's a cold day in hell standard. In the rare case, we'll do this impossible task of figuring out when would your impartiality reasonably be questioned. By way of sidelight anecdote, when I was co-reporter to the model code revisions that recently were adopted, one member of the commission proposed that we change this basic standard to whether your impartiality would reasonably be questioned. It got rejected. And the reason for that was it's easy enough to see when a reasonable person might worry. But when we have this probability thing, it gets tricky. And I think in some ways it's supposed to be tricky. It's supposed to be rare. Last point, I begin saying these two papers are great, and I spent all my time bitching and moaning. And that's unfair, because these papers are both really insightful and interesting. And Dmitry's last argument, and then I'll subside, has to do with this business of one way to deal with this problem is by procedural reform. In other words, the real problem, and on this point I could not agree more. The problem, and it deals with some of the issues we saw in the first session, dealing with this business of can a judge assess the extent of his own bias or even his own perceived bias? How many of us are able to say, how many of us would say, I'm a racist? No, we don't say we're a racist. And how many people would think I'm a racist? Well, no, partly, and it's worse for judges, because judges not only are like the rest of us, but they've taken an oath to be impartial. So to concede that you're partial is to say, whoop, I blew that code, damn, blew my oath. Even with the perception, is it easy for all judges to say, well, I could be perceived as a schmuck? No, because we talked about the appearance of impropriety. I have a code that says I shouldn't even appear to be partial. So when a litigant comes up to me and says, well, Judge, you look bad. What do you mean I look bad? I don't like that. I mean, it's a code problem. I mean, I don't, but more fundamentally, I swear not to do that. So judges are reticent about admitting that, understandably. So why not, instead of having judges grade their own papers, ship it over to a different judge? A lot of jurisdictions do that. And I would, on that front, I say I'm all for it. One word of caution, though. I was the reporter and consultant to the ABA Commission project, Judicial Disqualification Project, where the draft made that very recommendation. It got embedded in a draft resolution, and I think that was floated by the ABA. And for the vast majority of I think most judges who are very thoughtful about this, and say on the one hand, on the other hand, a lot of judges are accustomed to a procedure in which they don't decide these things. And most of them were thoughtful, but there were some judges that were very offended by it. I mean, who were offended by the notion, you're questioning my ability to be impartial and my commitment to impartiality by suggesting that I can't decide my own disqualification motions. And they went so far as not only to lobby for the withdrawal of that resolution, but to purge the website of the report itself, right? And so, in talking to Dmitry, I think I'm saying, Godspeed in this proposal. I think it's a very important one, but the lesson I gleaned is one that appeared on a bumper sticker I read on my way to the airport in Bloomington, which reads, "Meddle not in the affairs of dragons, for you are crunchy and good with ketchup." And I think and with that, I've got a plane attack.
We're already 15 minutes behind, so I will quit in, I think, about 13 minutes. We at least gain 2 minutes. If I'm in the middle of the sentence, I will just stop, and to get it all done, I'll talk too fast. I want to thank Paul very much for inviting me here. It's my first visit to the school, and it's very impressive. if we have elected judges, we cannot take the politics out of politics. That is, I think, inevitable. But we should not be naive and think that appointed judges will take the politics out of politics either. For example, I spent most of my life in Illinois, Blue Island, Illinois, a little suburb south of Chicago. There was a major way, the prime way to become a state judge in Cook County was to get the nod from Mayor Daley, either the real Mayor Daley or the present Mayor Daley, same thing. And if you want to become a federal judge in Cook County, a federal district judge, it's the same thing. That is, one was a primary in election, basically controlled by the Democratic Party. There's the overwhelming party in Cook County. Or if there's a Democratic president, the president turns to the mayor to find out who to appoint. In either case, there's absolutely no difference. Now, I know the legal realists have told us that prominent in the first third of the 20th century, they told us what judges do, even federal judges, is what they eat for breakfast. They just decide based on their prejudices. That's what Sotomayor said. The difference, though, is a very big one between her and the legal realist. She rejoiced in it. We're going to do it, let's do it. The legal realist said, therefore we have to be careful not to reflect our prejudices, to be as objective as we can. There was a big Supreme Court case some years ago on flag burning constitutionally protected as flag burning speech. And the court said 5-4 that it was. That is, how do you destroy a flag when it's torn and battered? You respectfully burn it and then bury the ashes. How do you destroy a flag to illustrate your opposition to the Vietnam War or the Iraq War or to the U.S. government? You burn the flag. What they were punishing in those cases is not what you were doing, burning the flag, what you were thinking while you were doing. The law prohibited sacrilege of the flag. Justice Scalia told me he was in the majority. He said, I know I'm acting objectively when I rule in a way that is contrary to what I really believe. Then I guess I have to be objective. And he said he slept well that night because he opposed flag burning with all his might and voted and ruled that flag burning was constitutionally protected. He thought that time he was being objective. Justice Stevens said flag burning is not constitutionally protected. You wonder how a 90-year-old can decide all these difficult cases. It's easy. What you like is constitutional. What you don't like is unconstitutional. Most of us would be reluctant to give them the remote control. But if you know what you're going to do, you just go ahead and do it. So judges should be objective. I'm not, by the way, arguing that Scalia is always objective. I think we criticize them when they are not being true to their principles, when they are inconsistent with their prior cases and pretend that they are not. But the judges should strive to be legally naive. I guess I'm legally naive and not a legal realist, as opposed to embracing it. I agree with many of the commentators that object to the appearance of impropriety. It's just too vague. That is, something's improper, all right? So something appears to be improper, and that means it's not improper, but it appears to be. To whom? It's got to be somebody who's fully informed. For example, there's I think a CBS or ABC, NBC news reporter called John Roberts. We can imagine a libel case. Someone is suing John Roberts for defamation. So it's Smith versus John Roberts, and then Chief Justice Roberts says this is constitutionally protected. And I could see somebody saying that doesn't seem right, that he would decide a case involving him. No, we have to mean somebody fully informed. If you're really fully informed, we don't need appearance. It's improper, it's not. Let's just decide what's improper, and instead of having a catch-all that is, I think, a trap for the unwary. Let's talk, for example, about the Caperton v. Massey case. It's talked about a lot today. It's talked in the news media. An easy case, yet it was 5-4. What was wrong with these four people? Why they couldn't figure it out? After all, Mr. Blankenship, he gave $3 million to Justice Benjamin's campaign, except that he didn't. He gave the state maximum of $1,000. He created his own independent expenditure. Justice Kennedy kept calling it a contribution, except once when he acknowledged what it was. It was an independent expenditure. The people didn't know each other. Mr. Blankenship is from what I've read, I don't know him at all, but he's a peculiar individual who has spent millions over the years of his own wealthy stock supporting whatever cause he believes in. He opposed the opponent of the incumbent Chief Justice because he believed that the decisions raised medical malpractice insurance too much. He spent millions on that. The Chief Justice himself, the incumbent who lost, the local newspapers thought that he really shot himself in the foot on the Labor Day speech before the election when he had a giant homophobic tirade that a lot of the people of West Virginia did not think was particularly judicial. Justice Benjamin decided at least a half a dozen cases involving the Massey Coal Company, ruled against Massey in every single one of them. Nobody asked him to recuse himself. The Attorney General of West Virginia was it the brother or a close relative of the defeated Chief Justice. And when West Virginia appeared before the Supreme Court, he never once, in fact he was asked about this, it never occurred to us to move to recuse the man who defeated my brother. I think it was his brother or uncle, whatever it is. Never occurred to me to refuse to do that. Mr. Blankenship was an officer in the Massey Coal Company. He owned 0.035% of the company. He spent, was it over $3 million to defeat the Chief Justice. Had the company been liable in the case that everybody's controversy, his share of it, if we pierce the corporate veil, would be $75,000. It does seem to me peculiar to spend $3 million in order to save $75,000. You wonder, the guy's either quite irrational, and this is all a product of both inherited money and generations of inbreeding, or that he was just really against this guy for a whole bunch of reasons, and most people don't vote for somebody, they vote against someone. After this case, the ABA, and I have it here, they tried to codify the decision in the case, and they couldn't do it. That is, they have restrictions on contributions, which have always existed, but they never say that you must disqualify yourself because somebody has made contributions that are not expenditures you have no control over. That is, Judge Benjamin wasn't, as far as we could tell, wouldn't even agree with many of the things that Blankenship said. He wasn't not going to be embracing them. This is not unusual. We had independent expenditures in the last presidential election where a lot of people attacked Obama for being foreign-born and his middle name was Hussein and so on, and John McCain rejected all of that. There may well be people who voted against McCain because the ads they attracted to McCain. Now there's a Citizens United case. That's another one that people talk about. Now corporations and unions can spend money not to contribute to candidates. They cannot do that at all. That's always been the law. But to have independent expenditures about issues or candidates. Well, about half the states already allow it, and somehow the world hasn't fallen apart. But more interestingly, the First Amendment in that case, involved there, doesn't say Congress shall make no law forbidding, restricting freedom of speech or the press except for corporations. It says Congress shall make no law. Now, in the oral argument of that case, it could have gone the other way. That was another 5-4 decision. It could have gone the other way. What did this government argue? In the first series of arguments, the Assistant Solicitor General said, when one of the justices, are you telling me that the government has the right to ban a book within so many days of the election, the electioneering communication? Yes, Your Honor. Well, that kind of surprised a lot of people, and the justices said, let's have re-argument in the fall. And then they had the re-argument, and now we have the new Solicitor General, Elena Kagan. She's had months to think about this, and they have the new oral argument. And the question is, can we ban books? And she says, the government has changed its position on that, Your Honor. We do not believe the government can ban books. However, it can ban pamphlets. Interesting. Thomas Paine, Common Sense, the pamphlet that started the Revolutionary War. The reason why we do not speak English with an English accent, I guess. The reason why we do not speak English very well at all because of that pamphlet that the government now says it can ban. Now, if you remember the facts of the case, this conservative group, Citizens United, made a movie, about a half-hour movie, on Hillary Clinton. It was a hatchet job attacking her. It is a little bit like 60 Minutes when they may put somebody on their TV show for 5 or 10 minutes. Or if you want another form of documentary, it's Fahrenheit 9/11. If Fahrenheit 9/11 came out within, 60 or 90 days of the election, electioneering communication, could the government ban it? They said yes. Now, I will grant you that this was a hatchet job on Hillary Clinton. It's not like the movies typically candidates make of themselves, which are more like biographies of the saints. But the question is, should the government be able to ban a movie or a pamphlet because it's electioneering communication? Again, this was independent expenditures by Citizens United that wanted to sell the thing. That is, it was video on demand. Now, we could say that the government could kind of ban this stuff. I, frankly, do not trust the government. The 3 lies of the 1990s, the 3 lies of today. In the 1990s, it is, I'm from the government here to help you, that the check is in the mail, and I'll love you just as much in the morning.
You clean that up. You just clean that up.
Yeah. And what is it today? My BMW is paid for. This is only a cold sore, and I'm from the government and here to help you. See, some things never change. Thank you very much.
Well, we've lost one person here, but we've got 3 ready to answer questions. As we were going through this, were there any that came to mind? Yes, sir.
The principal concern here seems to be engagement. The public, we the people. And as I was listening to you speak, I was thinking of some recent studies I've read regarding voter turnout. And if we are to have independent judiciary who can make unbiased opinions, and good luck with that, it seems to me that perhaps the legal community itself should get more behind public financing of elections, including those of judges. If we have an issue with contributions of 1,000 or 3 million, then perhaps we need to take a lesson from those countries in the developed world which have public financing of elections. And the interesting thing to me in reading these studies was that in those countries where there is public financing of elections, voter turnout is higher than in the United States. Your comments?
Who'd like to comment on
just
public financing?
Yeah, just a couple of questions. You look at voter turnout in the United States, it varies. It was very high at the time of the Vietnam War. It's getting higher now. If you want a very polarized country with issues that really divide us, then you get lots of voter turnout. A lot of the political scientists say that low voter turnout means people are relatively satisfied. They don't see the need to come to the polls. I'm all in favor of, I think we should do things, we should make it easy to vote, do it on a Saturday or Sunday instead of Tuesday, or make it a national holiday. But the fact that there's low voter turnout in some years, as long as we don't have registration requirements and others that make it hard to vote, as long as we don't have that, that's not a bad sign. It may be a relatively happy society. As for contributing to campaigns, it's interesting. We have the checkoff on your federal income tax. It won't change your taxes at all, but you can contribute $1 if you check it off. It'll take it out. Not going to increase your taxes. Now it's $3. You know why? Because fewer and fewer people are checking the box. I used to check the box until they gave my money to David Duke, the Klan member who ran in New Orleans. I didn't want my money going to that. We do know that if a challenger is going to beat an incumbent, it takes more money. There's all kinds of advantages of being an incumbent. And it is not a surprise that the main supporters of so-called campaign finance reform are the incumbents. I don't think it's a Republican versus Democratic issue. I think it's them versus us. And Now, West Virginia, by the way, is proposing their reform after Caperton is that you would raise a small amount of money, and then you would have $350,000 they give you, and you can't spend more than that in the general election. I think it is a shame that these judges' elections cost a lot. In Alabama, I think the most recent Chief Justice election cost more than the governor of the state. And I think that's because these judges are deciding things worth hundreds of millions of dollars. And you've got the Chamber of Commerce on one side and the plaintiffs' tort lawyers on the other side. I can identify the problem. I can't come up with a solution. I do worry, though, that if you have public financing, that it may favor the incumbents when it's low. You ought to give more to the challenger. And that secondly, under the decisions as we have them now, you could not prohibit a candidate from using his own money as much as he wants because he can't corrupt himself, which is, I think, why we are becoming more of a plutocracy. It is not a surprise that the great number of people in the Senate are independently wealthy. John Corzine on one of the billboards says, make him spend it all. I mean, and he did lose his re-election, but he spent tens of millions. The people that win or can run now are either movie stars, we know them already, people like former Governor Jerry Brown and Attorney General Jerry Brown, who we already know already, or people with lots of money like Meg Whitman. That's just the state, but it's replicated throughout the country. And given the Supreme Court cases, we're going to have more and more of the plutocrats running the country.
Other comments? Public financing?
Yeah, I mean, I'm generally in favor of public financing. I think one of the good things that came out of Caperton, and this is sort of what I try to get at during my talk, is states are thinking about reforms they can make to address the problem. So West Virginia has this pilot program where they're going public financing. There are constitutionality questions, not just spending your own money, but restricting people from spending money. And so, you know, it really depends on mostly the vote of Justice Kennedy, I think, but it really depends on how courts will approach restrictions to financing.
May I add a comment to that before?
Speak up so they can hear you.
The studies I've seen indicate that there is a limit to how much money each candidate gets.
Mm-hmm.
Oh, yeah.
And that's the only way it really works well, is that everybody, it's a level playing field.
Right.
No one
But
candidate
he's
can-
pointing out that there might be constitutional problems with it.
Yeah, I mean, and you know, like for example, President Obama, the way the federal law works is if you agree to accept this money, you have a limit. And he disagreed because it was more fortuitous, it was better for him to spend, he was just raising so much money. I can't blame him for that. He was less well known than his opponent.
Yeah, just one thing I want to add with respect to judicial elections and voter turnout. Sometimes voter turnout isn't even dispositive about the number of votes that come in on judicial elections because of a phenomenon known as roll-off. By the time you get to the bottom of the ballot, you're not even voting on judge. And what that means is that the people who do vote on judge are the strong preference people, sometimes not representative of what the general view would be anyway if people knew who they were voting for on the judicial candidates. So that's really an argument, not so much about finance, but about educating people on who the candidates are so that they will get all the way to the bottom of the ballot.
Okay, we have another question over here. Steve?
In support of the merit selection process, and without going into a lot of history, but if you look at the doctors and the dentists, and they're, you know, totally giving up their self accountability and peer review and self, you know, just totally gone to lay people on the statewide boards of examiners. And I think there's a danger in our profession and for our bench to turn over the selection of judges for all the right reasons that we know to the majority, given how loosey-goosey and really superficial elections are. As a trial lawyer, up until about 7 years ago, for 25 years, and knowing a lot of people in this town, and from being a member of Innet Court, and having a lot of interaction with judges and some of the other top trial lawyers in town, we have a darn good bench, and some of them were appointed by one political party, some of them were appointed by another political party. Sometimes you don't get the greatest judge on our bench, but for the most part, we have an excellent bench, and at least the local level, there is no reason, in my opinion, to let the general public, who really have no idea what we all do day to day, or what it's like to sit on the bench as these judges do, to elect someone that might look good in a 10-minute segment in 60 minutes, because you'll get crazies
on the bench, and you'll never get rid of them.
So, have we got a question there?
Do you agree?
Okay. Actually, well, I did see a question back here, so let's go with this.
I wanted to know if you had thoughts on whether which of the selection methods would affect diversity more. I practiced recently in a county that's very, neighboring county to Sacramento that has no minority judges on it yet, and I practice in the criminal courts trial practice, and the 40–50% of the defendants are minorities. So their perception of how they're being treated is different because they don't see anyone who comes from their background. And I was wondering if you had thoughts on which selection method would affect diversity more.
Yeah.
First of all, that's a really good question. There's been some reluctance, I know, in the Latino community to get away from electing judges because there's some sense, perhaps not correctly, that in judicial elections, the Latino population may do better. But in fact, a good merit selection panel includes as one of the factors in the process trying to ensure diversity. In Maryland, I recently attended some hearings about an effort to reform the process there. The trial court level in Maryland is the only one where judges are now elected. And the panel was mostly African American judges who had tried to be elected and who had initially been appointed and then they ran as incumbents and they lost. And the argument that they were making was that there were still pockets, counties in Maryland where there were significant racial biases, and in fact they fared very poorly in those elections. So that a well-structured merit selection panel can actually increase diversity.
Other comments?
Yeah, I think it's hard to give a concrete answer to that because the states that have election, almost no states, I don't think, have gone from elections to merit selection. So it's hard to do a comparative analysis within a state, so to do a true experiment. And I think some states, like New Mexico, recently went from sort of fully elections to sort of hybrid system where they have a merit panel that makes a recommendation to the governor makes an appointment, but that person still stands for a full election, not just a retention election, but only one time. And I think there they found that it did increase some minorities. More Hispanics and more Native Americans were at least past the merit process, the merit commission process. But again, it's really hard to compare apples to apples when you don't have states transforming from one system to another.
I haven't seen a thorough empirical studies. I have anecdotes as well. Illinois has 7 justices on the Supreme Court. It had a woman justice and chief justice long before the U.S. Supreme Court had a woman justice. The same thing for blacks. Illinois has a system where initially you're elected for most of the positions, and then you run against your record. That is, you run, it's an up or down vote for you, but you're not voting for somebody. You either vote for them or against them, but you're not voting for somebody else. And it's hard to beat somebody with nobody. Typically, the people who have been beaten in Illinois in that situation are judges who have made racist or sexist comments on the bench. That galvanizes the NAACP or the National Organization for Women, and the people are defeated because men and women and whites and blacks, no, we don't do that anymore. On the other hand, in Illinois, they have what's called associate judge, and the elected judges appoint the associate judge. And it's, I think, fair to say that the associate judges, many people think, are much better than the elected judges. Now, that's not appointed by the governor or the legislature, but it is appointed once removed from the process. The appointed system has worked well in Illinois for the associate judges, but there has been very little interest in moving. I think in part because racial groups are saying, now that we finally have power, now that we've moved away most of both the prejudice by white people as well as the difficulties on registry and so on, now you want to change the system. And so it's reluctant to find changes. But you may well find, you certainly will find judges who are not worried about raising money for the next election. Alabama, I think, is the worst system because every re-election is another partisan re-election against an opponent. And that makes it, you're constantly the forever campaign.
One more question here, John.
I'm glad the word hybrid came up because I was thinking when you were mentioning the merit system, but then you pointed out that the panel would pick certain people that a judge would pick. Why not just have the public pick at the point that there are a number of candidates that were professionally picked by lawyers as a publicly financed, controlled situation with no ability for anyone to spend except for the, so something new. Is that a doable idea? Or would it help solve problems?
I think it may. I mean, that is the, in the American Judicial Society, a not-for-profit group for years has recommended merit selection. Say at Illinois, every dean of every law school in Illinois for years has supported merit selection. The California state judges are among the best, among the best in the country. It's a leading court that is significant, and so there's, I mean, there's a lot to be said for merit selection. Though realistically, there doesn't. People say, I think judges are corrupt, but I don't want to change the system of doing it.
But I'm saying with public selection.
Yeah, no, that may be a way of doing it. You know.
Not so much an election in our normal, public, more of a public finance selection.
Okay, thank you so much, and Professor Paton will come up to finish things off.
First off, please join me in a round of applause for yet another terrific panel. And thank you again to Meryl and Dmitry for putting together papers. We'll make sure that materials, updated materials, are loaded up to the website if they're not included. And again, a reminder, with the assistance of the McGeorge Law Review, there will be a symposium edition published of the revised papers, and we'll make sure that that's also available online. A couple of administrative announcements. Just to wrap up the morning, there's a buffet lunch outside. Please join us for that. We'll reconvene in here at 1 o'clock to hear Justice Hedigan on 47 different traditions, one court. So if you haven't quite finished dessert or coffee yet, please bring it back in and join us at 1 o'clock until about 1:30. If we get technology to work, I understand that what our terrific tech folks have managed to do is actually capture the White House press conference, which goes about 7 minutes, and I'll try and arrange for that to be broadcast at the end of Justice Hedigan's remarks in the discussion period afterwards. So that will be at about 1:30, and then the afternoon panels will commence at 1:45. So thank you all for your attention. It's been a terrific morning. We'll take it from the national stage to California in the first panel this afternoon.